Providing a false name or address to a police officer at a drug premises is an offense under Section 143(3) of the Law Enforcement Powers and Responsibilities Act 2002, which carries a maximum penalty of a fine equivalent to 50 penalty units. To establish the offense, the prosecution must prove beyond reasonable doubt that 1. A police officer was authorized under Part 11, Division 1 of the Act to enter a premises. 2. You were at those premises. And 3. You gave a name that was false in a material particular, or an address other than a full and correct address. Part 11, Division 1 of the Act provides that a police officer in charge of an investigation into a suspected drug premises may apply to an authorized officer, such as a local court registrar or magistrate, for a search warrant if the officer suspects on reasonable grounds the premises is a drug premises. The division further provides that an authorized officer may issue the warrant if satisfied there are reasonable grounds for doing so. The division additionally provides that in addition to entry, search, seizure, and arrest powers, a drug premises search warrant empowers police to 1. Pass through, from, over, or along any other land or building for the purpose of entering the subject premises. 2. Break open doors, windows, or partitions. And 3. Do any other acts that may be necessary for the purpose of executing the warrant. The Act defines a drug premises as one which is used for 1. The unlawful supply or manufacture of prohibited drugs, and/or 2. The unlawful cultivation of prohibited plants. Prohibited drugs include amphetamines, cocaine, heroin, and LSD. Prohibited plants include cannabis and psilocybin, or magic mushrooms. You are not guilty of the offense if you establish on the balance of probabilities that you had a reasonable excuse for your conduct. General legal defenses to the offense include duress, necessity, and self-defense. If you are able to raise evidence of a general legal defense, the onus then shifts to the prosecution to prove beyond a reasonable doubt that the defense does not apply to the circumstances of the case. You are entitled to an acquittal if the prosecution is unable to do this.
Going to court. Call Sydney Criminal Lawyers on 9261 881 to arrange a free first conference. Watch our latest video here.